Welcome to the Justice Room. Your life, your rights, your options. Experience and learn from discussions with legal professionals and other experts about the law, its challenges, and how it could affect you. Here at the Justice Room. Welcome to the Justice Room. So what's the next step? Let's say that you get through the shelter hearing, there's probable cause, children remain in foster care. What's the next step?
All right. Well, whether the child is in foster care or placed with a relative, at the shelter hearing, the court will set an arraignment date. An arraignment date is where the parents will come and enter a plea of either denial, admission, or consent. Denial being similar to a criminal not guilty plea. Admit being similar to a guilty plea in criminal court, and consent being similar to a no contest plea in a criminal court.
Okay.
At arraignment, hopefully prior to that time in dependency court, there will have been a case plan conference with the DCF attorney, the parents' attorneys, the guardian ad litem if one is appointed, and the parents to determine what DCF is asking the parents to do to get their children back.
Now, this is at the arraignment, or is this, or because you mentioned case plan conference, and my understanding is that you can have a case plan conference and then you can have an arraignment as two separate things.
Yes.
Okay. So then which one comes first?
Well, it depends, because a case plan conference is not an actual in-court appearance. It's where the parties meet to determine what will be done in a case plan. The ideal situation is the case plan conference would occur before arraignment, and then the parent would know that they're going to agree to do the case plan and then go ahead and enter a consent and arraignment.
Okay.
However, a case plan conference can happen after arraignment as well. If it happens after arraignment, the parent can still come back later on for a plea hearing. Okay.
So, and I'm going to try to go pretty quickly through this if we can, but if not, hopefully you'll come back and do another show with us, because it seems like there's a little bit more that we can still cover about this, because in dependency cases, and I've worked some of them as an investigator, you have TPR cases, otherwise known as termination of parental rights. You have voluntary protective services you can get into. There are certain conditions of your case plans that must be adhered to, or there are consequences, just like there is in criminal court. There are pre-trials, there's normal trials, there are adjudicatory hearings that you can go to. There's a slew of other, I guess, items within dependency court that we can talk about. But to talk a little, to kind of close the show, to at least close this segment of the show, and hopefully if you have some time, we'll come back and we'll talk a little bit more about some of the other portions of dependency court that involve children in the legal system. Let's talk about voluntary protective services a little bit. How does that affect the child? And when would you enter into a voluntary protective service?
Well, Department of Children and Families does not have to remove a child if they feel like there's no imminent risk. Let's say there's a report called in that there was a domestic violence incident 5 months ago. DCF at that point, where's the imminent risk at? They could decide, okay, well, this report came in for an event that happened 5 months ago. We don't feel like we should remove the children, but we still feel like someone needs to do batterers intervention and the victim needs to do victims awareness. At that point, a protective investigator would discuss it with their supervisor that they just want to offer a voluntary plan where the court is not involved at all, where their parents just sign the voluntary protective services case plan, just agreeing to do classes without any court intervention.
Okay, I mean, because you also have, there's also conditions in where a child has to have some type of intervention, such as from a psychologist, a counselor, a psychiatrist, a therapist. Would that also fall under the same voluntary protective service?
A protective investigator could, if a child needs some type of counseling, offer that as well as a part of a voluntary case plan to avoid court intervention. Okay.
So, to close or to end this segment of dependency court, when would you seek the services of an attorney like yourself if you're found to be in a situation where you're going to dependency court? I mean, for example, in criminal court, if someone gets arrested or if someone's being questioned by law enforcement, you're most likely going to be looking for the services of an attorney or a lawyer or a legal professional pretty quick. So when would you make that determination here in dependency court?
Well, likewise, it's a pretty quick decision as well. Most people do decide that they need some type of representation, whether it be court-appointed or private, and it should be at the beginning stages because an attorney is not very useful to a parent. If the parent goes to court by themselves or has a trial without an attorney present, we're not very effective in the end stages.
Okay.
It's best to get the attorney as early as possible.
So as early as possible, meaning as soon as you've spoken with a protective investigator, because I've worked on cases where they're criminal cases and DCF gets involved through the protective investigator, and my clients have said, what do I say to this guy, or do I say anything at all, or the woman, because it could be a woman or a male that's a protective investigator, what do I say, what do I do? I can't give them legal advice as to what to do since I'm not a lawyer. However, my lawyer clients have always recommended that they say nothing or very little. I mean,
well, I'm going to be honest with you. When you're talking about speaking with a protective investigator, that person is not deemed a law enforcement officer that has to give Miranda warnings or anything like that. So if a protective investigator is talking to you about especially physical abuse of a child where there are marks, bruises, or welts, or serious injury, that might be the time, because that person is probably going to be charged with a criminal offense, to say, yes, investigator John Doe, I would like to speak with an attorney, because that protective investigator does not have the same restraints as a law enforcement officer would with regard to getting confession.
So your advice would be, if you're being interviewed,
fine to talk,
right? Okay.
And wait till you would like to speak with an attorney first.
Okay.
Yeah.
Thanks for coming on the show to do this first segment on dependency court. I'd love to have you back again to do another segment on this. I think that there's a lot of really good information here. Here at the Justice Room, we're trying to build an entire series on children in the legal system, and I'd hope that you'd contribute your services to us, or for your legal professionalism with us in advising the people what to expect with children in the legal system, especially in dependency court.
Sure, I'd be glad to come back.
So thank you for coming again today. I'd like to have you back soon again to talk a little bit more about pre-trials in dependency court, trials, adjudicatory hearings, termination of parental rights, voluntary protective services, counselors and psychiatrists, and what to expect there. Can somebody appeal a case in dependency court, whether in something like that? So there's a lot more that we can talk about, so I look forward to having you back on the show.
All right.
If you'd like to reach Ms. Thomas, you can reach her at her website, which is www.attorney4you.org. Or you can reach her via telephone. Her phone number is 407-574-8529. Ms. Thomas practices in dependency, delinquency, and several other practices of law, specifically on this show, dependency law. Again, to reach her, you can reach her at 407-574-8529. I'd like to thank you for listening to another episode of The Justice Room.